Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. This is lesson number 57. A federal statute provides that the United States Supreme Court has authority to review any case filed in a United States Court of Appeals, even though that case has not yet been decided by the Court of Appeals. The EPA, an agency in the executive branch of the federal government, issued an important environmental rule. Although the rule had not yet been enforced against them, companies that would be adversely affected by the rule filed a petition for review of the rule in a court of appeals, seeking a declaration that the rule was invalid solely because it was beyond the statutory authority of the EPA itself. The companies made no constitutional claim. A statute specifically provides for direct review of the EPA rules by a court of appeals without any initial action in a district court. The companies have filed a petition for a writ of certiorari in the Supreme Court requesting immediate review of the case by the Supreme Court before the Court of Appeals has actually decided the case. The EPA acknowledges that the case is important enough to warrant Supreme Court review and that it should be decided promptly, but it asks the Supreme Court to dismiss the petition on jurisdictional grounds. The best constitutional argument in support of the EPA's request is that A, the case is not within the original jurisdiction of the Supreme Court as defined by Article 3, and it is not a proper subject of that court's appellate jurisdiction because it has not yet been decided by any lower court. Option B, the case is appellate in nature, but it is beyond the appellate jurisdiction of the Supreme Court because Article 3 states that its jurisdiction extends only to cases arising under the Constitution. Or C, Article 3 precludes federal courts from reviewing the validity of any federal agency rule in any proceeding other than an action to enforce the rule. Finally, option D, Article 3 provides that all federal courts in all federal cases, except those within the original jurisdiction of the Supreme Court, must be initiated by an action in a federal district court. Take a few seconds and choose the best option now. The correct answer here is option A. The case is not within the original jurisdiction of the Supreme Court as defined by Article 3, and it is not a proper subject of that court's appellate jurisdiction because it has not yet been decided by any lower court. Let's look at the three other options and see why those three are incorrect. Option B. We can, in essence, eliminate these options right off the top. Option B says the case is appellate in nature. We can stop right then and there. There's no further analysis necessary. There's been no lower court decision, so the case is not ripe for any appellate level action. Now, C and D fall into the same category. They're discussing Article 3, which, if you recall, Article 3 in essence discusses the creation of the federal courts as well as notes the jurisdiction of the federal courts as anything coming from a federal question, meaning the Constitution itself. Now, C says Article 3 precludes federal courts from reviewing the validity of any federal agency rule in any proceeding other than an action to enforce that rule. Article 3 has no such language, so that's not a valid option here. Option D. Article 3 provides that all federal cases, except those within the original jurisdiction of the Supreme Court, must be initiated by an action in a federal district court. It, again, says no such thing. It actually simply directs the creation of the courts as well as the jurisdiction of the courts. It does not address anything having to do with the jurisdiction of the state Supreme Courts. Question number 2. Olivia owned Blackacre, her home. Her daughter, Dawn, lived with her and always referred to Blackacre as my property. 2 years ago, Dawn, for a valuable consideration, executed and delivered to Bruce an instrument in the proper form of a warranty deed purporting to convey Blackacre to Bruce in fee simple, reserving to herself an estate for 2 years in Blackacre. Bruce promptly and properly recorded his deed. 1 year ago, Olivia died, and by will, duly admitted to probate, left her entire estate to Dawn. 1 month ago, Dawn, for a valuable consideration, executed and delivered to Carl an instrument in the proper form of a warranty deed purporting to convey Blackacre to Carl, who promptly and properly recorded the deed. Dawn was then in possession of Blackacre, and Carl had no actual knowledge of the deed to Bruce. Immediately thereafter, Dawn gave possession to Carl. The Recording Act of the jurisdiction provides as such, no conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded according to law. Last week, Dawn fled the jurisdiction. Upon learning the facts, Carl brought an appropriate action against Bruce to quiet title on Blackacre. If Carl wins, it will be because A. Dawn had nothing to convey to Bruce 2 years ago. B. Dawn's deed to Bruce was not to take effect until after Dawn's deed to Carl. C. Carl was first in possession. Or D. Dawn's deed to Bruce was not in Carl's chain of title. Take a few seconds and choose the best option now. The best option here is D. Dawn's deed to Bruce was not in Carl's chain of title. The rule is that the recording system protects bona fide purchasers and mortgagees only. A bona fide purchaser is a subsequent purchaser who purchases the property for valuable consideration and without notice at the time of the conveyance. Notice can be actual or constructive. A wild deed is defined as a recorded deed that is not in the chain of title because of a previously unrecorded deed. A wild deed does not provide record notice to later purchasers of the property because the subsequent bona fide purchasers cannot reasonably be expected to locate the deed while investigating the chain of title to the property. Estoppel by deed is a legal doctrine under which a first party who purports to sell real property that the first party does not actually own to a second party must actually convey that property to the second party if the first party later acquires title to that property. In this case, Dawn did not own Blackacre at the time she conveyed it to Bruce. However, when Olivia died and left Blackacre to Dawn, estoppel by deed would have required Dawn to actually convey Blackacre to Bruce. The question stem, however, is asking us if Carl wins. In order for Carl to prevail over Bruce, Carl must be a bona fide purchaser who recorded first. However, in this case, Bruce promptly and properly recorded his deed, which defeats Carl's status as a bona fide purchaser. As such, the only way Carl would prevail is if Dawn's deed to Bruce was not in Carl's chain of title. Question number 3. Landholder was land rich by inheritance, but money poor, having suffered severe losses on bad investments, but still owned several thousand acres of unencumbered timberland. He had a large family, and his normal fixed personal expenses were high. Pressed for cash, he advertised a proposed sale of standing lumber on a choice 2,000-acre tract. The only response was an offer by Logger, the owner of a large integrated construction enterprise, after inspection of the advertised tract. For this question only, assume the following facts. Logger offered a fair price for the timber rights in question, and landholder accepted the offer. The 2,000-acre tract was an abundant wild game habitat and had been used for many years, with landholders' permission by area hunters. Logger's performance of timber contract would destroy this habitat. Without legal excuse and over landholder's strong objection, Logger repudiated the contract before commencing performance. Landholder could not afford to hire a lawyer and take legal action, and made no attempt to assign any cause of action he might have had against Logger. If Logger is sued for breach of the contract by a landholder's next-door neighbor whose view of a nearby lake is obscured by the standing timber, the neighbor will probably A. Lose as only an incidental beneficiary, if any, of the Logger landholder contract. B. Lose as a maintainer of nuisance litigation. C. Prevail as a third-party intended beneficiary of the Logger landholder contract. Or D, prevail as a surrogate for landholder in view of his inability to enforce the contract. Take a few seconds and choose the best answer now. The best option here is A, lose as only an incidental beneficiary of any of the logger-landholder contract. The call of the question here indicates that the neighbor who is not a party to the contract sued logger for breach of contract, a third party. Generally lacks rights under a contract. However, if the contract states that it is intended to benefit a specified third party, that intended beneficiary may, in some circumstances, sue. In contrast, an incidental beneficiary who is not mentioned in the contract has no actual right to sue. Here, the neighbor is not mentioned in the contract and is at best an incidental beneficiary of the agreement to clear the land. Because the neighbor is not an intended beneficiary, the neighbor will lose the breach of contract claim. So let's look at options B through D and see why they're wrong. B states he'd lose, which is accurate, as a maintainer of nuisance litigation. Well, that's not accurate. While this may be defined as nuisance litigation, he wouldn't lose on that basis. He'd lose on the basis of standing. C, prevail as a third-party intended beneficiary of the logger-landholder contract. So C requires a intended beneficiary situation. There's no discussion of that neighbor, nor is there any intent to benefit that neighbor in any way, shape, or form. So the contract in and of itself cannot be made out to be an intended beneficiary situation, as that neighbor is not mentioned in the contract, nor does it seem that either of the parties care or had any discussions with that neighbor prior to this contract. D, prevail as a surrogate for landholder in view of his inability to enforce the contract. There's no such standing here, in essence. Ultimately, what we're claiming is that simply because the landholder cannot continue forward, another party can take their place. That's not how standing works. The individual who brings the claim must, in fact, themselves be harmed. Question number 4. John is a licensed barber in State A. The State A barber licensing statute provides that the barber licensing board may revoke a barber license if it finds that a licensee has used his or her business premises for an illegal purpose. John was arrested by federal narcotics enforcement agents on a charge of selling cocaine in his barbershop in violation of federal laws. However, the local United States attorney declined to prosecute and the charges were dropped. Nevertheless, the Barber Licensing Board commenced a proceeding against John to revoke his license on the ground that John used his business premises for illegal purposes in the sale of cocaine. As a subsequent hearing before the board, the only evidence against John was affidavits by unnamed informants who were not present or available for cross-examination. Their affidavits stated that they purchased cocaine from John in his barbershop. Based solely on this evidence, the board found that John used his business premises for an illegal purpose and ordered his license revoked. In a suit by John to have this revocation set aside, his best constitutional argument is that A, John's inability to cross-examine his accusers denied him a fair hearing and caused him to be deprived of his barber license without due process of law. B, the administrative license revocation proceeding was invalid because it denied full faith and credit to the dismissal of the criminal charges by the United States Attorney. C, Article 3 requires a penalty of the kind imposed on John to be imposed by a court rather than an administrative agency. Or D, the existence of federal laws penalizing the illegal sale of cocaine preempts state action relating to drug trafficking of the kind involved in John's case. Take a few seconds and choose the best answer now. The best option here is option A. John's inability to cross-examine his accusers denied him a fair hearing and caused him to be deprived of his barber license without due process of law. The Due Process Clause prohibits state actors from depriving a person of liberty, life, or property without due process. The government must provide a fair process before it may deprive a person of life, liberty, or property. Depriving property is a loss of entitlement. An example of fair process is the ability to cross-examine an adverse witness. Here, the state a barbering license statute provided that the Barber Licensing Board has the power to revoke a barber's license. Before the board could deprive John the entitlement he has in his license, the board must provide a fair process. The board failed to do so when it relied on affidavits by unnamed informants who were not present or available for cross-examination as the basis for revoking John's license. Thus, John's best constitutional argument is that John's inability to cross-examine his accusers denied him a fair hearing and caused him to be deprived of his barber license without due process of law. So let's look at options B through C and see why they're incorrect. B, the administrative license revocation proceeding was invalid because it denied full faith and credit to the dismissal of the criminal charges by the United States Attorney. That is a very poor presentation, and it's a very poor argument. Ultimately, the criminal charges and any state claims are separate and apart and not reliant upon one another. So B would not be an appropriate answer because it's simply untrue. C, Article 3 requires a penalty of the kind imposed on John to be imposed by a court rather than an administrative agency. That's incorrect. Article 3 does not make mention of any such rule. So that can be eliminated. And finally, D, the existence of federal laws penalizing the illegal sale of cocaine preempts state action relating to drug trafficking of the kind involved in John's case. Now, we know that's inaccurate because ultimately there are federal drug crimes and there are state drug crimes. So the reality is that D is not a viable option, as well as it's not based on reality either. Question number 5. The state of Red sent 3 of its employees to a city located in the state of Blue to consult with a chemical laboratory there about matters of state business. While in the course of their employment, the 3 employees of Red negligently released into local Blue waterways some of the chemical samples they had received from the laboratory in Blue. Persons in Blue, injured by the release of the chemicals, sued the 3 Red state employees and the state of Red in Blue state courts for the damages they suffered. After a trial in which all of the defendants admitted jurisdiction of the Blue State Court and fully participated, plaintiffs received judgment against all of the defendants for $5 million, which became final. Subsequently, plaintiffs sought to enforce their Blue State Court judgment by commencing a proper proceeding in an appropriate court of Red. In that enforcement proceeding, the state of Red argued, as it had done unsuccessfully in their earlier action in Blue State Court, that its liability is limited by a law of Red to $100,000 in any tort case. Because the 3 individual employees of Red are able to pay only $50,000 of the judgment. The only way the injured persons can fully satisfy their Blue State Court judgment is from the funds of the state of Red. Can the injured persons recover the full balance of their Blue State Court judgment from the state of Red in the enforcement proceeding they filed in a court of Red? Option A, yes, because the final judgment of Blue Court is entitled to full faith and credit in the courts of Red. Option B, yes, because a limitation on damage awards against Red for tortious actions of its agents would violate the Equal Protection Clause of the 14th Amendment. Option C, no, because the 10th Amendment preserves the right of a state to have its courts enforce the state's public policy limiting its torts liability. Or option D, no, because the employees of Red were negligent and therefore their actions were not authorized by the state of Red. Take a few seconds and choose the best answer now. The correct option is A, yes, because the final judgment of Blue Court is entitled to full faith and credit in the courts of Red. The full faith and credit clause of the Constitution requires that courts in one state give full faith and credit to judgments of the state courts of other states. Question number 6. Alex contracted for expensive cable television service for a period of 6 months solely to view the televised trial of Clark, who was on trial for murder in a court of the state of Greene. In the midst of the trial, the judge prohibited any further televising of Clark's trial because he concluded that the presence of television cameras was disruptive. Alex brought an action in a federal district court against the judge in Clark's case, asking only for an injunction that would require the judge to resume the televising of Clark's trial. Alex alleged that the judge's order to stop the televising of Clark's trial deprived him of property, his investment in cable television services, without due process of law. Before Alex's case came to trial, Clark's criminal trial concluded in the conviction and sentencing. There do not appear to be any obvious errors in the proceeding that led to the result in Clark's case. After Clark's conviction and sentencing, the defendant in Alex's case moved to dismiss that suit. The most proper disposition of this motion by the federal court would be A. Defer the action on the motion until after any appellate proceedings in Clark's case have concluded, because Clark might appeal. His conviction might be set aside. He might be tried again, and television cameras might be barred from the new trial. Option B. Defer action on the motion until after the Greene Supreme Court expresses a view on its proper disposition, because the state law of mootness governs suits in federal court when the federal case is inexorably intertwined with a state proceeding. C. Grant the motion, because the subject matter of the controversy between Alex and the defendant has ceased to exist and there is no strong likelihood that it will be revived. Or D. Deny the motion, because Alex has raised an important constitutional question whether his investment in cable service solely to view Clark's trial is properly protected by the Due Process Clause of the 14th Amendment. Take a few seconds and see if you can come up with the right answer now. The correct answer is C. Grant the motion, because the subject matter of the controversy between Alex and the defendant has ceased to exist and there is no strong likelihood that it will be revived. To avoid being dismissed for mootness, there must be a live controversy at all stages of review. If the plaintiff's injury ends after the lawsuit is filed, the suit will be dismissed as moot. In this case, Alex brought an action asking for an injunction that would require the judge to resume televising Clark's trial. However, Clark's criminal trial concluded before Alex's case came to trial, without any obvious errors in the proceeding that led to the result in Clark's case. It is unlikely that Clark's case will go back to trial. Alex's action is now moot because there's no longer a live controversy regarding the televising of Clark's trial. As a result, the federal court should grant the motion to dismiss the suit because the subject matter of the controversy between Alex and the defendant has ceased to exist and there's no strong likelihood that it'll be revived. But let's analyze the other options and see why those are inaccurate. Option A. Defer action on the motion until after any appellate proceeding in Clark's case have concluded, because Clark might appeal. His conviction might be set aside. He might be tried again. And televised cameras might be barred from the new trial. So here's the issue. The issue is that ultimately the filed action is based on the proceedings which have in fact already terminated. If there were any new proceedings, they'd be considered new filings or new proceedings. So as a result, the current litigation wouldn't necessarily apply to those new proceedings because it would be based on the action of the initial court and that judge's jurisdiction and that judge's discretion. That judge's discretion ends once the case is over. If there's a new case filed, now you have a different judge reviewing that matter. So as a result, the prior order to not permit cameras in for whatever reason may no longer be valid nonetheless. So as a result, A would be inaccurate because all of these mights are not very good reasons to keep a case open. Or to grant standing on someone. Again, we don't look at what might happen when it comes to standing. We care about what is actually, in fact, happening. The word might repeated so many times in option A should be a dead giveaway that it's not a very good option. Now, B, Defer action on the motion until after the green Supreme Court expresses a view on its proper disposition, because the state law of mootness governs suits in federal court when the federal case is inexorably intertwined with a state proceeding. It actually doesn't make very much sense. It's basically saying the court should defer a decision until after the green Supreme Court expresses a view on its proper disposition. So there isn't even anything pending before the Supreme Court that we're told of. So ultimately, arguably under B, we could keep this motion open forever ad infinitum. It'd make absolutely no sense. So B is not a proper, potential, or reasonable option. D, deny the motion because Alex has raised an important constitutional question, whether his investment in cable service solely to view Clark's trial is properly protected by the due process clause of the 14th Amendment. So we have a few issues here. Remember that state actors are stopped from committing issues of depriving an individual of due process. Here, there's nothing specifying that the cable company is a state actor. As a matter of fact, as we know, generally they tend to not be state actors. So as a result, we're already should be questioning option D. Finally, given the issue of mootness and the fact that there's already been a decision, again, not very likely that this matter should proceed, and the characterization of this important constitutional question is extremely important. It's excessive. This is not an important constitutional question. Whether you're entitled to have particular coverage of a particular event, you could arguably say is a First Amendment right of media or of access to things. But, however, it would be an issue of standing for you because you are not the broadcaster of those things. You are the receiver of those things. So perhaps if a media company bought that suit, that'd be a little bit different, and D might make a little bit more sense. But an individual who is the viewer bringing the suit grants absolutely no standing unless that individual was the individual in the courtroom reporting themselves. That could arguably be a very different scenario. Question number 7. Company wanted to expand the size of the building it owned that housed company's supermarket by adding space for a coffee house. Company's building was located in the center of 5 acres of land owned by company and devoted wholly to parking for its supermarket customers. City officials refused to grant a required building permit for the coffee house addition unless company established in its store a child care center that would take up space at least equal to the size of the proposed coffee house addition, which was to be 20% of the existing building. This action of the city officials was authorized by provisions of the applicable zoning ordinance. In a suit filed in state court against appropriate officials of city, company challenged this child care center requirement solely on constitutional grounds. The lower court upheld the requirement even though city officials presented no evidence and made no findings to justify it other than a general assertion that there was a shortage of child care facilities in city. Company appealed. The court hearing the appeal should hold that the requirement imposed by city on the issuance of this building permit is A, constitutional because the burden was on company to demonstrate that there was no rational relationship between the requirement and a legitimate government interest, and company could not do so because the requirement is reasonably related to improving the lives of families and children residing in city. Option B, constitutional because the burden was on company to demonstrate that this requirement was not necessary to vindicate a compelling governmental interest, and company could not do so on these facts. Option C, unconstitutional because the burden was on city to demonstrate that this requirement was necessary to vindicate a compelling governmental interest, and city failed to meet its burden under that standard. Or option D, unconstitutional because the burden was on city to demonstrate a rough proportionality between this requirement and the impact of company's proposed action on the community, and city failed to do so. Take a few seconds and choose what you think is the best answer now. The correct answer here is D, unconstitutional, because the burden was on city to demonstrate a rough proportionality between the requirement and the impact of companies' proposed action on the community, and the city failed to do so. The rule is that government restrictions on development must be justified by a benefit that is roughly proportionate to the burden imposed by the proposed development, or there will be a taking. If, however, the benefit is proportional to the burden, there's no regulatory taking. In this case, the burden would be on the city to demonstrate a rough proportionality between this requirement and the impact of the company's proposed action on the community. The city officials, however, presented no evidence and made no findings to justify its requirement other than a general assertion that there was a shortage of child care facilities. As such, the court should hold this requirement unconstitutional. And the fact that there was a general statement or a generalized statement is problematic, because at the end of the day, should there be a targeted or directed ruling with regards to a particular company taking on the onus for a lack of child care facilities within a city, that is in all likelihood going to be deemed an inappropriate or an improper taking. Question number 8. Ali owned a tract of land known as Peter Hill. During Ali's lifetime, Ali conveyed the easterly half, situated in the municipality of Hawthorne, to Abel, and the westerly half, situated in the municipality of Sycamore, to Betty. Each of the conveyances were promptly and properly recorded, and they contained the following language. The parties agree for themselves and their heirs and assigns that the premises herein conveyed shall be used only for residential purposes, that each lot created within the premises herein conveyed shall contain not less than 5 acres, and that each lot shall have not more than one single family dwelling. This agreement shall bind all successor owners of all or any portion of Peter Hill, and any owner of any part of Peter Hill may enforce this covenant. After Ali's death, Abel desired to build houses on 1/2 acre lots in the East Peter Hill tract as authorized by current applicable zoning and building codes in Hawthorne. The area surrounding East Peter Hill in Hawthorne was developed as a residential community with homes built on 1/2 acre lots. West Peter Hill was in a residential area covered by the Sycamore zoning code, which allowed residential development only on 5 acre tracts of land. In an appropriate action bought by Betty to enjoin Abel's proposed construction on 1/2 acre lots, the court will find the quoted restriction to be A, invalid because of the change of circumstances in the neighborhood, B, invalid because it conflicts with the applicable zoning code, C, valid, but only so long as the original grantees from Ali own their respective tracts of Peter Hill, or D, valid because the provision imposed an equitable servitude. Take a few seconds and choose the best answer now. If you chose option D, valid because the provision imposed an equitable servitude, you'd be correct. An equitable servitude is a promise to do or not do something concerning the land that binds the original parties and their successors. In this case, Ali conveyed East Peter Hill to Abel and West Peter Hill to Betty. Each of the conveyances contained the agreement not to create any lots less than 5 acres on either of the lands. This equitable servitude was to be enforced by any owner of any part of Peter Hill. Betty, as owner of West Peter Hill, could enforce the 5 acre provision of the equitable servitude. As such, the court will and should find the quoted restriction to be valid because the provision imposed an equitable servitude. Now let's review the other 3 options and discuss why they may be invalid. Option A, invalid because the change of circumstances in the neighborhood. Now, in fact, that's not necessarily important because the change of circumstances in the neighborhood does not affect the original contract and the original agreement. So that being said, arguably, any change of circumstances could reasonably be a basis to excuse oneself from a contractual obligation. That would likely not be the result that any court of any competent jurisdiction will be deciding. So as a result, A is likely inaccurate. B, invalid because it conflicts with the applicable zoning code. Now, contractual terms do not have to comply with applicable zoning code, only that they must be appropriate under the applicable zoning code. Otherwise, that particular portion of the contract may be stricken. That being said, here, the limitation is well within the applicable zoning code, it seems, because the zoning code permits for half-acre lots, and here we're discussing 5-acre lots, so we're talking about something 10 times the size, so that would obviously be appropriate given the zoning code. But that being said, the zoning code in and of itself is not a limitation and does not extend the authority under the contract. C, valid, but only so long as the original grantees from Ollie own their respective tracts of Peter Hill. Now, arguably, that would be a very invalid position to take, because if one wanted to get around this limitation, then one could simply sell their portion of the land, perhaps to a corporation that they themselves own. That would now not be the original contracting party, and you'd in essence have escaped from the original obligation. That being said, let's look at the language. Remember, the language says any and all subsequent owners as well, heirs, etc., etc. So the contract carries with it to new purchasers. So as a result, C is invalid because the change of ownership would not affect the contractual obligation. Question number 9. 3 years ago, Adam conveyed Blackacre to Betty for $50,000 by a deed that provided, by accepting this deed, Betty covenants herself, her heirs, and assigns that the premises herein conveyed shall be used solely for residential purposes, and if the premises are used for non-residential purposes, Adam, his heirs, and assigns shall have the right to repurchase the premises for the sum of $1,000. In order to pay the $50,000 purchase price for Blackacre, Betty obtained a $35,000 mortgage loan from the bank. Adam had full knowledge of the mortgage transaction. The deed and mortgage were promptly and properly recorded in proper sequence. The mortgage, however, made no reference to the quoted language in the deed. 2 years ago, Betty converted her use of Blackacre from residential to commercial without the knowledge of or consent of Adam or of the bank. Betty's commercial venture failed, and Betty defaulted on her mortgage payments to the bank. Blackacre now has a fair market value of $25,000. The bank began appropriate foreclosure proceedings against Betty. Adam properly intervened, tendered $1,000, and sought judgment that Betty and the bank be ordered to convey Blackacre to Adam, free and clear of the mortgage. The common law rule against perpetuities is unmodified by statute. If the court rules against Adam, it'll be because A, the provision quoted from the deed violates the rule against perpetuities. B, the bank had no actual knowledge of and did not consent to the violation of the covenant. Or C, the rights reserved by Adam were subordinated by necessary implication to the rights of the bank as the lender of the purchase money. Or D, the consideration of $1,000 was inadequate. Take a few seconds and choose what you think is the best answer now. If you chose option A, you'd be correct. The provision quoted from the deed violates the rule against perpetuities, and congratulations for getting a question right on quite possibly one of the most difficult ideas to comprehend in law school. Now, if you remember, the rule against perpetuity states that for a future interest to be valid, the interest must vest, if at all, within 21 years after some life in being at the instrument's effective date. An executory interest with no limit on time within which it will vest violates the rule. However, the rule does not apply to future interests retained by the grantor. Here, we have a future interest which is conveyed, and includes a future interest which is retained by Adam, who is the grantor. So the rule against perpetuities seems like it doesn't in fact apply. However, the question itself asks if the court rules against Adam. It'll be because, so we have to analyze from that perspective. So while it's unlikely that a court will find that this violates the rule against perpetuities, the question is specifically asking you to reason out why the court would in fact rule against Adam. Let's look at the answer choices. Answer choice B, C, and D do not give the court a reason to rule against Adam. Let's review them. Now, if we look at option A, the bank had no actual knowledge of and did not consent to the violation of the covenant. Here we're discussing bases why Betty is in violation or why Betty did something wrong, but in reality, we're not addressing Adam's concerns or his interest whatsoever. Let's look at C. The rights reserved by Adam were subordinated by necessary implication to the rights of the bank as the lender of the purchase money. Now, C says Adam's rights were subordinated by necessary implication. While that may actually, in fact, be accurate, that would not, in fact, remove the clause which permitted Adam to buy for the $1,000. D, the consideration of $1,000 was inadequate. The contract specifically stated that price, and it discussed why it would state that price. So as a result, the contract here would be the ultimate trump card and would be the basis under which the terms are gauged, not anything else or not in relation to anything else. So D is not relevant. As a result, A would really be the only option here. So the way this would work would be ultimately that if the court interprets that this transaction or this covenant would carry long past to Adam's heirs as well, and would arguably vest 21 years past the life of Betty, then the court could theoretically take the position that this is an invalid agreement because it violates the rule against perpetuities, and as a result, find against Adam. Question number 10, last question in this grouping. Great job for making it this far. State Y has a state employee grievance system that requires any state employee who wishes to file a grievance against the state to submit that grievance for final resolution to a panel of 3 arbitrators chosen by the parties from a statewide board of 13 arbitrators. In any given case, the grievant and the state alternate in exercising the right of each party to eliminate 5 members on the board, leaving a panel of 3 members to decide their case. At the present time, the full board is composed of 7 male arbitrators and 6 female arbitrators. Ellen, a female state employee, filed a sexual harassment grievance against her male supervisor and the state, and the state's attorney exercised all of her 5 strikes to eliminate 5 of the female arbitrators. At the time she did so, and stated that she struck the 5 female arbitrators solely because she believed women as a group would necessarily be biased in favor of another woman who was claiming sexual harassment. Counsel for Ellen eliminated 4 males and 1 female arbitrator, all solely on grounds of specific bias or conflicts of interest. As a result, the panel was all male. When the panel ruled against Ellen on the merits of her case, she filed an action in an appropriate state court challenging the panel selection process as a gender-based denial of equal protection of the laws. In this case, the court should hold that the panel selection process is A, unconstitutional because the gender classification used by the state's attorney in this case does not satisfy the requirements of intermediate scrutiny. B, unconstitutional because the gender classification used by the state's attorney in this case denies the grievant the right to a jury made up of her peers. C, constitutional because the gender classification used by the state's attorney in this case satisfies the requirements of the strict scrutiny test. Or D, constitutional because the gender classification used by the state's attorney in this case satisfies the requirements of the rational basis test. Take a few seconds and choose what you think is the best answer now. Now, if you chose option A, you'd be correct. Unconstitutional because the gender classification used by the state's attorney in this case does not satisfy the requirements of intermediate scrutiny. The rule is that gender-based classifications must meet intermediate scrutiny. Furthermore, in both civil and criminal cases, the discriminatory use of peremptory challenges on the basis of gender by either defense or the prosecution violates equal protection. In essence, if you recall back to the Batson case, this would be a perfect example of that. In this case, Anne, the state's attorney exercised all of her 5 strikes to eliminate 5 of the female arbitrators, and at the time she did so, Anne stated that she struck the 5 female arbitrators solely because she believed women, as a group, would necessarily be biased in favor of another woman who was claiming sexual harassment. Based solely on this, the court should find that the selection was unconstitutional based on an improper gender classification, which in fact does not meet the requirements of intermediate scrutiny. Let's look at the other 3 options now and see why they are inaccurate. Let's start with option B, unconstitutional because the gender classification used by the state's attorney in this case denies the grievant the right to a jury made up of her peers. Now, this is relatively straightforward as to why this would be inaccurate. There's no jury being discussed here at all. It's a panel of arbitrators, right? That's not a jury. A jury would be a jury of one's peers. That is accurate, and Batson challenges generally apply to juries. However, here we're looking at a different scenario, which is a panel of arbitrators and has nothing to do with juries themselves. So as a result, B is not relevant. C, constitutional, because the gender classification used by the state's attorney in this case satisfies the requirements of the strict scrutiny test. While that would be good if it were to, however, the strict scrutiny test is not the appropriate test here. We're looking at intermediate scrutiny. So the relation for this particular type of violation in strict scrutiny inherently misapplies the facts to the wrong test. So C is inaccurate. D, constitutional because the gender classification used by the state's attorney in this case satisfies the requirements of the rational basis test. Now, it goes from one extreme. C talks about the highest level of scrutiny, strict scrutiny. Now D is discussing the lowest level of scrutiny, rational basis. We know that it's not rational basis either. We know that it's intermediate scrutiny for gender. So C and D inherently fall to the wayside and are improper. And as we discussed, B is improper for the reasons of noting the jury where a jury doesn't exist. So B, C, and D are inapplicable, and you're only left with A as a possible correct answer and the only viable option, in fact. As always, thank you for joining us on Bar 10, where it's our hope to help you prepare for the bar exam 10 questions at a time. To that end, we upload material regularly, and we have at least 55 other programs much like this, addressing MBE material specifically. Feel free to review, use, record, share, do whatever it is you wish with the material. If you should have any other further questions or things that you'd like us to address, feel free to comment down below. Don't forget to like, subscribe, and click the notification bell so you can be notified anytime we upload new content. That being said, thank you for allowing us to be part of your bar preparation journey. We look forward to helping you in the future. Again, don't hesitate to reach out and ask any questions or discuss any material that you'd like to see or hear in the future.